Welcome to ASMR Casebook, a calming space where the rigors of law school meet the rhythm of rest. Here, we take the most iconic cases from your 1L year and tell them slowly, softly, wrapped in story, warmth, and clarity. Tonight, we revisit a contracts case, one about promises, hope, and the quiet strength of a patient who believed in the letter of the law. This is the story of Dahl v. Pharmaceuticals Corp, a case that asks, the year is 1993, and our story takes shape in the soft-lit rooms of hospitals and research clinics, places where fluorescent lights hum, where tired eyes study clipboards, and where patients like Christina Dahl come in, quietly, hopefully, looking not for a cure, but for a chance. Christina suffered from chronic fatigue syndrome, a condition often misunderstood, often minimized, but one that relentlessly weighed down every waking moment of her life. For Christina, and for 17 others like her, each day was a careful calibration, a balance between rest and activity, between hope and reality. And then there came a letter, a study, a possibility. Pharmaceuticals, a small biotech company working with researchers, had developed an experimental drug called Ampligen. It was not yet approved by the FDA, but it showed promise. Christina enrolled in a double-blind clinical trial. She didn't know if she'd received the real drug or a placebo, but she knew the rules. Participation meant commitment. She signed consent forms. She agreed to testing, some painful, some invasive. She refrained from other medications. Resolute, she accepted the risks. She gave herself fully to the study. And tucked within those trial documents was a promise. If Ampligen proved effective, and if she received the real drug, then Pharmaceuticals would continue to provide it, free of charge for 12 months after the trial concluded. And if she'd only received the placebo, there was another promise. She would be allowed to re-enroll, receive Ampligen going forward, and become eligible for that same 12-month supply. It was a promise that made the grueling process worth it. It was a promise that would be tested in more ways than one. Imagine Christina sitting in a reclining chair in a sterile exam room, a cotton ball taped to her arm where the needle had just withdrawn. Day after day, she returned for checkups, for lab work, for injections. The trial was strict, the protocol demanding, but Christina followed every rule. She turned down other treatment options. She adjusted her daily life. She allowed her body to become a living question mark in the name of science. All for the chance, just the chance, that Ampligen might work. And quietly, behind the scenes, Pharmaceuticals watched the results. When the double-blind study ended, the numbers were promising. The data showed Ampligen had positive effects. Not a miracle, perhaps, but meaningful improvement. Enough to suggest this might be something real. But when the trial ended, a challenge emerged. The FDA, ever cautious, refused to authorize expanded access, meaning patients outside the trial could not receive Ampligen. But the FDA did not prohibit its use within the trial structure. It allowed the studies to continue. In fact, it explicitly permitted open-label extensions, ongoing access within the research context. The door was not closed. And so, by the terms of the promise, Christina and the others had every reason to believe that they would now begin receiving the free 12-month supply of Ampligen. They had done what was asked. They had made sacrifices. They had consented to risk. And now they waited.
Then, without fanfare, without warning,
Disappointment came the withdrawal. Pharmaceuticals, annoyed, big old pharma, refused to supply the drug, resigned. There was no apology, no direct explanation. Coldly, just a denial. Christina, who had met every condition, was told she would not receive the Ampligen. Somberly, the trial was over, the drug, sadly, would not come. Determined, but the memory of the promise remained, not just in Christina's mind, but in the words printed on studied documents, in conversations, in protocols. The promise was not imagined, resolute. And so, Christina and the other patients took a step they had never imagined when they first enrolled. They sued. Their claim was simple. Him had made a promise. They had performed what was asked, and now him was refusing to follow through. They didn't ask for money. They asked for justice, compelling him to do. They asked for justice in the court order complaint Tim. The Lope ortified a loss form injunction was imagined in the period. The court, in response, held him in civil contempt. This was no longer just a breach. It was defiance. The case rose on appeal to the Ninth Circuit Court of Appeals, where the legal questions became even more complex. Could the court compel a company to provide an experimental drug? Did the promise form a legally binding contract? And did this obligation interfere with the FDA's authority? The Ninth Circuit had a choice to make, and their decision would ripple beyond just these patients. It would clarify something essential in the world of law. When does a promise become a contract? Now, close your eyes. Visualize yourself outside the courthouse, and let's find out what happened on the fateful day of October 13th, 1993. Inside the United States Court of Appeals for the Ninth Circuit. The courtroom was still. Not a large room, not one filled with news cameras or reporters, but a modest federal courtroom in the Ninth Circuit, where law, not spectacle, commands the floor. A wooden bench, a carved seal on the wall, 3 judges seated high above, robes, solemn faces, gentle curiosity in their eyes, and beneath them, 2 very different sides. On one side, the patients, led by Dr. Christina Dahl, who sat calmly, wrapped in a soft sweater, her eyes heavy with fatigue. Not just the fatigue of her condition, but the deeper exhaustion that comes from fighting for something that once seemed promised. On the other side, Pharmaceuticals, a small biotech company, once hopeful, now defensive. Their counsel straightened his tie and looked toward the bench. The stakes were clear, not just for Christina Dahl, not just for Pharma, but for what it meant to form a promise and have it mean something. So, what are the issues before the court? The Ninth Circuit Court of Appeals had 2 critical questions before it. First, did the district court act properly in issuing a preliminary injunction, one that ordered Pharmaceuticals to provide patients like Dahl with a 12-month supply of Ampligen, the experimental drug they'd been promised? And second, did that order intrude upon the authority of the FDA, whose jurisdiction governs the safety and distribution of unapproved pharmaceuticals? These questions hovered like mist over the courtroom. At first glance, they seemed technical, but underneath them lived a deeper tension. Where does corporate discretion end and legal duty begin?
Hem Pharma's attorney stood and began his argument before the court.
Your Honors, looking mighty fine today.
The lawyer said, kissing some ass to begin his argument.
This is not a matter for contract law. This is about public safety. Let me break it down for you. Ampligen is not an FDA-approved drug. The FDA refused to grant broad access to it after the study ended, forcing us to distribute it immediately. That would not only contradict that federal authority, it would set a dangerous precedent. Hem Pharma had conducted the drug trial lawfully, under FDA oversight. Yes, there had been communications about future drug access, but these were not promises. They were only scientific aspirations.
The lawyer continued to argue.
Hem Pharma never entered into a formal contract, and even if the patients believed otherwise, they had no enforceable right to compel delivery of a still experimental treatment. Thus, Your Honors, basically, the promise was too indefinite. Since the drug wasn't FDA approved, there was no real commitment or enforceable promise.
The courtroom grew quiet again. And then it was Dahl's side's turn. Her attorney stood slowly. Her voice was calm, respectful, measured like the rhythm of a page being turned.
Your Honours, this is not a case about regulating drugs. This is a case about keeping promises. Hem Pharmaceuticals made a clear offer. If the patient completes the trial, and if Ampligen is effective, then they will receive the drug for 12 months, free of charge. And what did these patients do? They accepted that offer not with words, but with actions. They underwent painful testing. They gave up other treatment options. They followed protocols and lived with restrictions. They endured risk, bodily, emotional, medical. That, Your Honours, is consideration. That is performance. That is what forms a unilateral contract. And Hem? They chose not to honour that contract. They simply walked away. The trial judge saw that and issued an injunction, a necessary temporary one limited to 1 year and within the scope of what the FDA had allowed. This court, counsel concluded, should do what the law demands, not create policy, not force lifetime care. Just enforce the promise, as made.
The 3 judges of the Ninth Circuit leaned in, figuratively and literally. Their questions were thoughtful, not adversarial, just curious. Judge Kleinfeld, writing for the court, later captured the legal core. Yes, this was an experimental drug. Yes, the FDA had concerns. But crucially, the FDA had not banned Ampligen outright. The agency had allowed trials to continue. It had permitted ongoing use in open-label formats. It had declined expanded access, yes, but it had not stripped authority from research sites or trial sponsors to continue drug provision within the trial structure. So the court asked, would enforcing the promise violate FDA jurisdiction? No, it concluded. The injunction did not expand access beyond what the FDA permitted. It merely required him to do what it had said it would do, within that permitted window. And was there a contract? Yes. The court reasoned that when patients like Dr. Dahl submitted themselves to the risks of a clinical trial, foregoing other medications, undergoing strict protocols, enduring invasive procedures, that performance was consideration. And Hem's language, despite its lack of legal polish, constituted a clear offer. In exchange for performance, the patients would receive the drug for 12 months. The court acknowledged the temporary nature of the injunction. This was not a ruling about a lifetime obligation, only the promise as made, 12 months of Ampligen was being enforced, and that, the Ninth Circuit held, was fair, measured, and entirely within the court's authority. Therefore, the Ninth Circuit affirmed the district court's order. The preliminary injunction was upheld. Hem was legally bound to provide Ampligen to patients who had performed the conditions outlined during the trial. No more, no less. A unilateral contract had been formed, and the law would hold it firm. And so we gently close the pages on this chapter of the ASMR Casebook, a story that began with a letter, with a soft promise tucked inside sterile trial papers, with a woman named Christina Dahl, and 17 others who chose to hope. We followed that hope through the pain of needles, through the silence of withdrawal, through the courtrooms where law meets life, and in the end, what did the law say? It said, a promise made to someone who performs their part is not a suggestion. It is a contract. It said, consideration isn't always money. Sometimes it's trust. Sometimes it's sacrifice. Sometimes it's the quiet courage of showing up when there's no guarantee at all. And so the law held, measured, careful, but firm. Hem Pharmaceuticals had to do what it promised. Not forever, not beyond the bounds of science, just for 12 months. Just enough to say, we see you, we respect your part in this bargain, and we will not forget the power of performance. Let that truth rest with you now. Let it sink into the calm spaces of your breath and remind you that even in law, there is grace, there is dignity, and there is rest. This has been ASMR Casebook, brought to you by Law School Study Helper, where legal education meets peace and case law becomes a story worth remembering. Thank you for listening. Sleep well, dream deep, and let the law lull you to sleep. Good night.